Welcome everybody to this second roundtable of our training course. Today we will speak about asylum in practice. How does the asylum system work in three different national contexts: Italy, Germany, and Greece. So we will go through some of the, let's say, specificities of each national context. I will be very quick in introducing our three guests today. I start with Lorraine Leith, who is the coordinator of the Lesbo Legal Center. There is a project that supports and provides legal support to people on the move on the Aegean island of Lesbo in Greece. Then we have Andreas Eivelshauser, that you already know, who is a legal expert on asylum and immigration law in Germany and longtime member of the Refugee Law Clinic in Berlin. And then Jacopo Di Giovanni, lawyer specialized in immigration and asylum law in Italy, and also coordinator of the legal aid service of the Migration and Asylum Law Clinic of the University of Roma III in Rome. So let's start, and Lorraine asked me to go first because then she has to leave for, let's say, last minute difficulty, let's say, in staying with us. So I leave you the floor immediately, Lorraine, so that you can do your presentation. And of course, I thank you all for being with us today.
Yes, hello, thanks for the introduction and for the invitation. And I will just a brief intro to why I have to leave early. There's a 16-year-old Roma boy who was shot and killed by the Greek police. So there's been a call for demonstrations across the country. So I appreciate you letting me leave early for this. I will leave my contact in the chat. So if people do have questions, I can get back to you afterwards. But I will just get into it then about the asylum procedure in Greece. I will give a bit of history of what's happened in Greece since the EU-Turkey deal, because I think it's important to understand the context now is something that has been developed gradually, especially over the last 6 years, of a gradual restriction of access to Europe. Through changes in the asylum procedure and through changes in the practice of the Greek authorities at the border between Greece and Turkey. So going back to 2016, well, first, just a few comments on the framework, which you'll hear as well from others that are presenting today. But Greece, as part of the European Union, is part of the common European asylum system. So the asylum procedures here are implemented into Greek law according to EU regulations and directives. So essentially, this asylum system, which is set up, is talked about as a protection mechanism, but in practice, what it does is serves as an exclusionary migration policy, which limits access to European residency for people who are entering Europe, especially from the global south, people who are entering who don't have the ability to get visas to travel here by regular means, and that are forced to enter the asylum procedure as the only way to get residency in Europe. So I can talk a little bit about some of the problems within the procedure itself, but just as a reminder that this policy itself of forcing people to either apply for asylum or return to the countries they came for, and asylum procedure itself, which really limits people's access to residency in terms of having to show that you face persecution based on your personal identity, or that you're at serious risk of harm in your home country, which of course many people migrating now can't meet that very narrow definition. So also we'll hear a little bit about how the Common European Asylum System, in particular the Dublin regulations, affect people's ability to move where they want to, even when they get to Greece. So I won't go into a lot of details about that. Maybe in Andreas's presentation about what is happening in Germany, this will be a bit more relevant. But going back to Greece, what's happened since 2016 was this EU-Turkey statement, which was not a treaty. It wasn't actually law, but there was a press, basically a joint press statement by the EU and Turkey, which in effect then was implemented into Greek law, and which did various things that changed the asylum procedure since 2016. The first major change was that it created a new border region of the Aegean Islands. So people who arrived to Greece from Turkey on the Aegean Islands no longer could continue their journeys to mainland Greece and to the rest of Europe, but were restricted from leaving the islands until their asylum procedures was processed. Through the EU-Turkey deal, it was also this idea that Turkey should be responsible for processing people's asylum cases, that Turkey was a safe country, so if people pass through Turkey, they should be forced to go back there and apply for asylum there, rather than in Europe. And this was a policy that was pushed from the European Union, that was pushed from the European Commission. And in practice, what we saw in Lesbos and throughout the Aegean Islands was actually the Greek Asylum Service didn't go along with it as much as Europe hoped. What we saw in the result of this was essentially the Greek Asylum Service. They found that Turkey was a safe third country for Syrian nationals, but for everyone else, they recognized the limitations of access to protections which are supposed to be guaranteed to refugees in Turkey. And with this practice, I mean, I say that this was pushed by Europe, not just based on, you know, the political statements by European politicians, but also by the involvement of the European Asylum Support Office, which was a EU entity providing support to the Greek government and many other countries, especially in the southern border states of the European Union. And they were across the board rejecting people's asylum cases when they apply. So people arrive in Greece, they're registered, they apply for asylum, and they're first assessed as to whether Turkey is a safe country for them. The European Asylum Support Office across the board was rejecting, making opinions, carrying out the interviews and then making opinions saying that Turkey was a safe country for these individuals. But the Asylum Service of Greece, to its credit, which I won't give much credit to the Greek Asylum Service, but on this, they were actually finding that Turkey doesn't offer the protections for all other nationalities except for Syrians. And actually it was appealed through Greek courts, and the Greek Council of State, which is like the highest administrative court of Greece, confirmed that Turkey was in fact a safe country for two Syrian nationals who appealed their case. So roughly from 2016 until 2019, with the change of government in Greece, this was the situation that people who are arriving had to go through the procedure. They're stuck on the island until their procedure is processed, but most people were somehow able to get through the process and they weren't subject to being sent back to Turkey. A small aside that there was also an exception to this border procedure, to this requirement that people show that they are not safe in Turkey, for people who could show that they met certain vulnerabilities. And often, almost everyone who is forced to make this dangerous sea crossing from Turkey, they will have passed through some trauma which would make them vulnerable under the Greek categories of vulnerability, which was legal categories of who's considered vulnerable, including pregnant women, people who have post-traumatic stress disorder. So imagine you have this dangerous crossing from Turkey. You're forced to live in these camps in horrible conditions, which we won't really get into today because we'll focus on the asylum procedure. But essentially everyone ends up developing post-traumatic stress disorder, because if you're not able to go on with your life and process the trauma that you've suffered, you do have PTSD. So most people were able to kind of get around these border procedures by showing that they do have a vulnerability. So it was somehow a loophole, which the new government closed. So from 2019, there were various changes to the asylum procedure. One of these being closing this loophole, so saying that those who are vulnerable, they still had to stay on the islands. They still had to show that Turkey was not a safe third country for them. And this, of course, is a political decision. It's not based on any protection that's actually given to asylum seekers in Turkey. A few other changes that happened since the new government came into power in mid-2019. Well, this shift of not allowing people to get out of the border procedures and to freely leave the islands led to an increase of congestion on the islands, especially in late 2019 and into the early 2020, which led to kind of an explosion of, well, it was a condensation of people on the islands and at the same time, the pandemic arrived. So this led to kind of this boiling tensions on the island and tensions between Greece and Turkey. I won't go into all the different geopolitical tensions between the two countries, but this led to, in March of 2020, that the Greek government suspended the right to seek asylum for 1 month. So there was one month in which people who arrived, Greece had announced that no one would be allowed to seek asylum, that everyone who arrived would be returned to Turkey. This in practice didn't happen, but it was several weeks after this announcement by Greece, which all the people who arrived were not registered. They were held in detention centers that were set up in the ports of various islands, on Navy ships that were brought in to house people in horrible conditions, where us as legal actors and people who had arrived didn't know what would happen, because the announcement of Greece was that they would not allow anyone to apply for asylum, and people would be directly returned to Turkey. This eventually was condemned by the EU, but it took several weeks, and I think it was kind of a test of Greece to see how much they could get away with. At this same time was exactly when the practice of illegal pushbacks at sea started to escalate. So it became apparent that they couldn't create a legal regime to prevent people from applying for asylum. So they started to implement an illegal regime of preventing people from applying for asylum, wherein people who arrive to Greece are basically hunted down, captured, and taken back out to sea in what is now widely documented as a systemic practice of pushbacks from Greece to Turkey. This, of course, is not within the asylum procedure of Greece, but I think it's important to mention in terms of what's actually happening on the ground and what is happening in terms of people's access to the asylum procedure when they're arriving to Greece from Turkey, because most people, when they're arriving now, they're actually being pushed back before they're allowed to apply for asylum. One other shift that's happened since the government shifted was an expansion of this notion of Turkey being a safe third country. So it was in June of 2021, so now a year and a half ago, that there was a joint ministerial decision. So this is basically an announcement by the Ministry of Migration that Turkey is safe, not only for Syrians, but for nationals of Afghanistan, Somalia, Bangladesh, and Pakistan. And they applied this not only for people arriving to the Aegean Islands, but people who are arriving to Greece from Turkey, no matter where they cross. So also people who are crossing in the land border of northern Greece. In practice, what does this mean? This means everyone from these nationalities, when they apply for asylum, it's not considered why they left their countries, if they're safe in their countries of origin. It's only considered if Turkey is a safe third country for them. And because this is a political decision, it's essentially applied across the board from everyone from these nationalities. So they're being rejected. Their applications for asylum are being rejected as inadmissible based on this decision, which of course is a political decision, that Turkey is a safe third country for them. And I think the nationalities that are on this list is indicative of the political nature of this decision. It's the highest number of people who are arriving to Greece right now from Turkey are from these 5 nationalities. So it's not because there are certain protections that are given to these individuals in Turkey. It's only because these are the highest number of people that are arriving in Greece. A few other shifts that we've seen is that with the changes to the asylum procedure, another amendment was to add a fee for people who are applying for asylum for the 3rd time. So this has come into place over the years in Greece. Well, since 2020, actually, also since March of 2020, Turkey is no longer accepting people from being deported from Greece to Turkey. So this started in March of 2020 with the pandemic and the closure of the borders, but is continued until today because of the ongoing tension between Greece and Turkey. So what this means in practice is that everyone whose asylum cases are rejected, they're not being deported. They're not being deported to Turkey because Turkey isn't accepting anyone from Greece, and they're not being deported to their countries of origin because Greece doesn't have bilateral agreements with most countries that they would want to deport people to. So in essence, these people are somehow trapped in Greece, sometimes even trapped on the islands and not able to leave, who don't have any legal status. And so often what people do is they apply for asylum again, because it's, again, the only option for them in terms of regularizing their status in Greece. And they end up applying for asylum various times because it's the only way to have some sort of like legitimate documentation to show that they are registered with the Greek government, that they're at least going through a procedure, but they're getting rejected over and over and over again. And often they're getting rejected only on the basis that Turkey is a safe third country. So these are families who have come from Syria, families who have come from Afghanistan, who have a prima facie case that they're eligible for asylum, but they're not being allowed to even show this because they're being rejected at the first stage. And one amendment to the asylum law was to add a fee to apply for asylum the 3rd time. And it's a fee of 100 euros per person. So that means if you're a family of 5, it's 500 euros to apply again. So this has also drastically restricted people's access to asylum, even people who are prima facie refugees under this even very narrow definition of who's eligible for refugee status. So this is the context we have in Greece right now. With the practice of pushbacks, of course, most people who arrive, they're not able to apply for asylum at all. And those who do arrive are now going through an even more accelerated procedure. Often they're registered and they have their interview within a week of arrival, which of course makes access to legal aid very difficult. I could talk a bit as well about some of the problems in the procedure because, the law itself is fundamentally unfair, and it's a system that's designed to keep people out of Europe. But then even within this procedure, there's problems from registration to the appeals. I mean, just a few examples, and then I'll turn it over to the next speaker. But for example, Frontex, who is involved in the registration of new arrivals in Greece, they're systematically or at least quite regularly over the years are registering people who are minors, and they say that they're under 18 when they arrive. Frontex is registering them as adults, and then it's almost impossible to change this biological data later in the procedure. People need to show original documents from their country of origin. These original documents are often not accepted. So what it means is that many children who would, for example, be eligible to join family members in other European countries, who would be eligible for certain protections as children, are being denied that from the moment they arrive and are registered. The appeal procedure, I also want to mention, because I think something that's quite different in Greece than in other European countries. The appeal procedure in Greece is still an administrative procedure. It's not going before a judicial authority. So it's a written administrative procedure, which in practice, the decisions of the appeal committees are only serving to rubber stamp the first instance decision. So the latest statistics out of the asylum service itself is that 94% of the cases that are rejected again on appeal. So in Greece also, which I know is somehow different from Italy, there's almost no chance to change an asylum decision on appeal or an administrative court, which is what comes after the administrative appeal. So also it's important to give more support and effort as in the first instance. Just a few comments and then I'll close. I don't want to take up too much time. I think what does it mean to work as a lawyer within the system when it's a system that is fundamentally unfair, and provide legal support to people who we know aren't going to really have a chance because of all these limitations around throughout the procedure and the political nature of these decisions. So, I mean, I think one thing that is important to keep in mind and that we try to keep in mind in terms of our decision making and how we decide which cases we take on, what we focus in terms of litigation, how to best support people on the move. One thing that we've been very clear in our litigation and strategy and who we decide to support and how, is that we don't want to be advocating for a more efficient, a more an asylum procedure without all of these procedural errors, because fixing the errors in the procedure, you still will have a system that's designed to exclude people. So our focus has instead been to focus on litigation or advocacy that can push for, recognizes people's right to move where they want to move. So focusing a lot on Dublin type cases, or on lifting of geographic restrictions of people who are stuck on the islands, and focusing on these things rather than, for example, fixing procedural errors in this system, or fixing, for example, conditions in camps that shouldn't exist to begin with. But I think I'll leave it at there. I could go on and on about, all the other procedural problems in the interviews as well. There's problems in interpretation. There's problems in the way questioning is conducted, in particular of vulnerable people who have experienced sexual violence, LGBT individuals who are asked questions that are more like an interrogation and don't comply with UNHCR guidelines for how these cases are supposed to be assessed. Really inappropriate and homophobic questioning in these interviews as well. And these interviews are conducted not only by the Greek Asylum Service, but by the European Asylum Agency. So I will leave it at that. And I will leave my email in the chat so that if anyone has questions, they can also send them to me. But thanks again for the invitation, and we will be in contact.
Thank you, Lorena. There are already a couple of questions. I will forward them to you. And okay, take care. And I think we'll see you in a couple of days again. Thanks. I don't know who wants to go after. Andreas, Jacopo.
Do you want to go, Jacopo? Would you like to go, Jacopo? I'm happy to go last.
Okay, so I'll go now. You hear me? Okay. I will not go into the European legal framework. I will just try to describe how one person can apply for asylum and what the procedure turns out to be in the Italian legal framework, and also prompted by what the speaker who just finished before me said, I will also try to explain what we do and the way we try to help people as the legal clinic. So we also have a smaller experience, of course, but we have an experience of pushbacks at the border in the northeastern front, mainly, but people who make it either by boat or in any other way, make it into the Italian territory, they just apply for asylum in any police office. The problem can be for people who are rescued at sea and then are detained because they don't have any legal permit to stay here. You need a visa and you need to enter through the official borders. If you do not, then you are not allowed to stay in the country. So people may be detained and then they may apply for asylum from within the detention center. This starts an accelerated procedure, and there is a presumption that the application is without grounds, that it is only made to delay or elude the return to their country. But the most of the people who apply, they do it when they are free. So they just go to the police office. The problem is that the police office often do not let people in to lodge their application. So this is the first obstacle, just not by the law, just by the personnel presiding. They are army soldiers presiding outside the police office, immigration offices, and they do not let people in. So this is the first problem. People have been sleeping all night long for days, for weeks before the immigration offices. Once they manage to lodge their application, let's assume it's their first application, then once they manage to lodge it, things are quite easier than in Greece, because they are allowed to stay. They have no restrictions to their circulation, so they can lodge the application in Rome and then move to the north, to the south, even travel to the islands, Sardinia and Sicily, or anywhere within the Italian territory. And they can work. Law provides that the asylum seeker can work after 60 days from the date their application is registered. And this means that they can have a means to provide for themselves. They can also be allowed in so-called migrant camps. Sometimes they are good places with services. More often they are rundown places with very little services, only providing accommodation and food, no services at all, but still they are a service granted virtually to all asylum seekers, at least on their first application. Let's see what happens next. The application will be evaluated in virtually all cases, at least in the first application will be evaluated through an interview. And the interview will be held in the office of the administrative body, who then will decide. Now, the law was changed in 2017, and it has only started working in the way that it was changed from a couple of years. So there's been a delay in enforcing the law. And the law now provides that the asylum seeker have to submit the full address where they will receive a summons for the interview. Now, this seems a very stupid issue. I mean, it's an address, and then they will look for me, or I can tell my new address. It's not so easy, because when you give the address in the first moment of your application, maybe you do not know the exact house number, or maybe there is not your name on the doorbell, on the letterbox, or maybe then you move out of that place. In all of these cases, if you do not submit your new address and your new address is not registered in the system, you will not receive the summons to the interview, and then your application will be suspended and then closed. Even if you are compliant and make sure that the address is full, complete, exact, and updated, then the summons letter is sent through the mail, and the Italian postal service is not famous for being always delivering. So sometimes the letter does not reach you, and you cannot prove that it did not reach you without your fault. So you are maybe waiting for 2, 3, 4 years, and then your application is possibly suspended or canceled, and you don't even know. But this is only one problem on the course of the application, because when you have successfully received the letter for the interview, then you go, usually almost always, without a lawyer, because this administrative procedure does not require a lawyer. And if you want to have a lawyer, you have to pay for the lawyer, because it is not possible that the state pays a lawyer for you. Then you can explain your story, they will ask you questions, and then they will tell you, oh, we will let you know our decision. And again, the decision comes through the post at the same address that you were careful to tell. Many times, the applicant in the interview tells the commission, the asylum commission, now my address is this. So you could guess that they know their address, and then they can send their decision to the address that the applicant has just told them. This is not the case, because if you do not send a letter through registered mail or registered email, which nearly no applicant can have, because you need other documents. We'll go we will also talk about what kind of documents an applicant can get. But anyway, if you don't have proof that you sent your new address through these channels, then you will not receive the decision. And this is also a very big problem, because if the letter is returned to the sender, that is to the commission, then within 20 days, the law says it is just as good as if it were delivered. So the days start counting for your term to lodge an appeal if you're not satisfied with the decision. This can be a very big problem, because if you do not lodge an appeal against a negative decision on time, your case is closed and there is no way to open it again. The only way is to lodge a second application, which is only admissible if it is based on new facts or new evidence, and these new facts or evidence, the applicant must also prove that he was not able to submit in the first place. So a second application is only admissible if the applicant has something new to submit to the Commission and can prove that it is not their fault that they did not submit it in the first place. Let's go back for 1 minute to the kind of documents that an applicant can get. I said they can work. Yes, they can work with a regular contract, which is not so fashionable in Italy. So most people are in theory allowed to work with a contract, but as many also Italians or many people with a regular permesso, they don't get a job contract because they are kept working without a contract. That's because employers do not want to pay taxes, and also they do not want to be held responsible for accidents on the job. But no matter what the reasons are, people, also applicants, usually don't get a job contract. But also, if they get a job contract, they may face some difficulties to receive their wages, their salary, because you need a bank account to receive your wages from your employer. And to open a bank account, you need a document. Now, when you have applied for asylum, yeah, you do get a document, which is a valid document to do everything you have to do in Italy, including opening a bank account, including registering as a resident. But in part, the government in 2018 tried to make it impossible to register as a resident when you were an asylum seeker. That law was voided by the Constitutional Court. But anyway, still many administrations hinder and try not to accept these registration requests. And also private actors like banks do not accept the asylum seekers' documents to open a bank account. So we have many people who can work, who maybe do have a job contract, but cannot receive their money because the bank will not let them open a bank account. Not having a job contract can also determine the result of your application. That is because in our internal system, we not only have the international protection, which derives from the European framework, but we also have our special protection, which is the result of several interventions by the governments. One in 2018 tried to remove this national form of protection. Then it was reintroduced, even with a wider range of hypotheses. And one of the reasons to grant this special protection is when there is a risk of a damage to the private family or private life, as granted by the European Court of Human Rights. And in the private life, one important factor is also your integration through your job. So if we have to compare the situation of a person who has been working, has been integrating, has been building not only family, but also personal relationships, a network, like enrolling in school, and the most important element for this evaluation is usually managing to get a job, then we compare the situation of this person to the situation that this person would face if they were returned to their own country, where they have to cut all ties that they have been building up in Italy. Then we can see that sending them back would be a damage to their private life. And this can be also construed, helped by the fact that asylum procedures take long, meaning that during the time for the asylum procedure to be evaluated, a person can form a family, they can have children, they can get married to someone who has a permit, or they can find a job, or they can go to school. So the inefficiency of the system, which is a typical Italian trait, in a way is also helping the asylum seekers, because of course, if the case was open and shut in 2 months, okay, you apply for asylum, we hear you next week, and in 2 weeks you get the result. What kind of integration might you get if you just come out of a boat? You don't know the language, you don't know anyone, unless you already had some family ties or some relationships, which is quite unlikely. So the length of the application procedure can help, but the decision is often a negative decision. And differently to other countries, we have a higher rate of judicial decisions overturning the commission. So I have no statistic data. I only have the impression that I get from even my local perspective, because I work in Rome. We tend to only have cases in Rome, but I can say most of the cases we represent and we fight in court, because we do not usually go to the commission with our clients, but we try and help them in the appeals against negative decisions. Most of the cases are granted. And this is in part because the court is probably more open, at least the court in Rome, but I would say also the other courts, and I dare say even the Supreme Court, and I will have to say something about the Supreme Court and their role in the application for asylum. But that is also because if it takes so long, if you have a person who's been an asylum seeker for like 4, 5, 6 years, well, unless they really are hopeless or just unable to find any way around, usually they can manage to bring something to the court to help them. But let's say that even the court does not grant any form of protection. What happens next? Also, in 2017, so the same government, the law by the same government that provided this trick with the postal address and the summon letters that never come, introduced another very important change in the law. The government took away a second degree of evaluation by the courts. We have 2 degrees in the court system for virtually everything. If you get a parking ticket, then you go to the court, and if you're not satisfied, you go to a higher court that will evaluate again on the ground. So they will see if you were right or wrong. They decided that this was too much for asylum seekers, that 1 degree was enough. And they say so because it was important to make a case go quicker. So they say, okay, let's take away 1 degree of evaluation. That will make things quicker. Of course, what they meant was, let's give them less chances to succeed. Because of course, if you have 2 degrees, then you have 2 evaluations. You have 2 chances to make your claims heard by a judge. We still have the Supreme Court. So the Italian Constitution provides that all decisions that impact on personal freedom, on individual freedom, and all sentencing decisions by the courts can be appealed before the Supreme Court. But the Supreme Court will not evaluate the case on the merits. That means not hearing if the fact deserves if the applicant deserves the international protection. Usually they have to review the decision by the lower judge, by the judge who has evaluated, and check if the judge made any mistakes. And they can only do that if the appeal is technically admissible, which is nearly never, because it is very difficult to lodge an admissible appeal to the Supreme Court. So what happens after 2017? That all the cases that were rejected by the courts of first instances, no, maybe not all, but at least half of them went straight to the Supreme Court. The Supreme Court is already swamped by an enormous backlog of cases that they have to hear. I do not know how many cases they receive every year, but I can see that they give out something like 80,000 decisions every year. They are like 100 judges. So I don't do the math, but I can see it's a huge number of decisions for every judge to give out every year. The quality of the decisions, meaning just the chance for someone who reads the decision to understand and to use that decision to evaluate if a case is groundless or has merit, is sometimes very poor. So they're not very useful, but they are the decisions that set. We don't have the precedence system, but anyway, it's very hard for a judge, for a lower judge, to not conform to the Supreme Court decision. And what happens to our asylum seeker if the application is rejected also by the Supreme Court. The case is finished, totally finished. Then they can lodge a second application, but within the limits I said before. So only if they have new grounds, new reasons. Usually, the new facts or new reasons would be would qualify for the special protection, because maybe during all this time, even while they were rejecting his application or her application, the applicant was working, and so maybe they have built a family which was not considered in their first application. Okay, so maybe they would aim to the special protection. Can they apply for special protection straight away? Yes, it took some time to understand this, but yes, they can. Should they do that? Usually, we do not advise to do that, because when they apply for special protection, they don't get any document saying that they can stay in Italy for the time of the evaluation, which can be up to 7, 8 more months. And during that time, they're not even able to work. So you have one person who was working right until the moment they rejected the application for asylum. The next day, they say, no, but I was working. The Supreme Court could not evaluate this because this is something that is not a technical error by the first judge, which is what the Supreme Court is to check. So maybe they can say, okay, but with my integration, I will qualify for special protection. But if I lodge an application for special protection, then I cannot have a job contract. I cannot have residency. I cannot have a bank account. So people may apply again for asylum. And we know, and they know, and probably the Commission knows, and the court knows, that the application for asylum is aimed to the special protection. But the system being as it is, it's the only way to keep working. And also, if it is not granted the special protection, then this time it is not as easy to stay in the country during the appeal, because when you apply in the first place for asylum, then you're allowed, with some exceptions, you're allowed to stay in the country until the decision of the first judge, at least. When you apply for a second time, if you are not granted any, well, if your second application is ruled not admissible, then you are not allowed to stay in the country, but the judge has to allow you if you lodge an appeal. So it makes it very difficult for someone who has already integrated themselves to stay and to keep that integration. It's like trying to take away everything that was built up to that moment. Like, you were working, yeah, but now you cannot work anymore. And if you apply for special protection, you cannot work until you are granted the special protection. And if you apply for international protection again, but we find that the application is not admissible, then you are not allowed to stay unless the judge says so. And so your status on the in the Italian territory comes and goes. You are allowed to stay, then you're not, you're allowed again. And this is, of course, a difficulty, not only for working and for document, but also for the mental state of people, because they face an uncertainty which is very hard to bear. Let's not speak about the things that they have undergone before coming to Italy, but even in Italy, they are exposed to this uncertainty on their status. If you apply for special protection, or if you are granted special protection, you do not qualify for any accommodation at all. Now you would say, but if you are working, if you are integrated, then you don't need accommodation. That's not always the case, because maybe you work, but you are paid way too little to provide for an accommodation. Maybe you have a family to take care of, and you are the only breadwinner with 2, 3, 4 people. So that is also something lacking in the surroundings of the special protection. I think I am losing my battery on the earpods, so if you will not hear me, I have to switch to the computer microphone. Anyway, I think I could close now, unless there is something which I should mention. Carlo, you think?
I don't know. There's a question for you, but I think we can leave questions and answers at the end. What do you think?
Okay.
Round of applause, basically after Andreas. And then,
okay.
Of course, if you want to add something that came to your mind after, I mean, it's...
Okay, so let's say I charge up my microphone while Andreas is speaking. Okay.
Thanks, Jacopo.
Okay, then I will take the floor. Thank you so far. That was very interesting, and also I think we might try and compare some things that you talked about and that I might touch upon. Also, I am not sure, because I assume that a lot of the people who were here, I think 2 or 3 weeks ago when I gave the presentation, are here again. I might not go through every aspect of the asylum procedure, but rather highlight some things, because because I would repeat myself probably a lot. A bit less structured than last time, I tried to assemble a small presentation here. Let me see what I can now get the right one here. You see that? So that I think that is the slide that I prepared for last time. That kind of outlines in an incomplete way the asylum procedure in Germany, and that I'm not going through in every detail anymore, because we already did. Also this slide is one that I showed last time. I think most interestingly, we might talk a bit about the admissibility procedures first in Germany, because this is really something that might be a bit of a contrast to the situation in Greece and Italy, and which kind of makes the whole European asylum system picture a bit more complete. And as you know, and I think you already had also a presentation on the Dublin regulation earlier. The Dublin regulation kind of says which country is responsible for taking or for checking your material grounds or your merits of your claim for asylum, and has kind of two main principles, which are one state only and no refugees in orbit. Basically, it says that you get one procedure within Europe, one material or claims procedure, and there should not be a situation. That's the second thing, no refugees in orbit, which is a weird term, but there should not be a situation where one country says, I'm not responsible for the procedure, the other country says, I'm not responsible, and someone is kind of left in between, and you don't even get to the stage where you can bring your material claims. In public discourse and media discourse, at least in Germany, the only thing that is always said is that the Dublin regulation says wherever you enter the European Union, that's where you have to stay. This is definitely not the full story. And we've lawyers in Germany have become very adept with working with the Dublin regulation, so that you can really kind of maneuver the system in a way that it's really not the outcome if you're represented by a good lawyer, that you have to definitely go back to the one country where you entered the European Union. There are nevertheless a lot of obstacles to overcome and a lot of things that can go wrong. But just to outline this a bit, these are in the Dublin regulation the criteria that are checked. So before you get to this first entry criterion, anyway, if you are a minor, you can lodge your application wherever you set foot in. So if you are a minor and you come to Germany, Germany will be responsible for your claim. Then there are the family reunification provisions in the Dublin regulation that basically allow you to have your procedure where your family already is, and family in this case means kind of the core family. So if you're a minor, your parents, or if you have minor children, that you can be reunified with them. And I think this is very interesting also in a way, or very, this is a point where it's very necessary to work together with lawyers in different countries in the European Union. And we did this a bit with this project that we founded on Samos, and I'm very sure that oh dear, now I forgot the name of our colleague before, that I'm sure that they work a lot with the family reunification cases as well with Legal Center Lesbos, because there's a lot of provisions and a lot of deadlines that you have to keep in mind. First, that the state that you get to first, so Italy or Greece, notifies Germany that you have, if you have family in Germany, that they would have to notify Germany that that you want to be reunified, and there has to be a deadline kept for this. And then the procedures take often a very long time, and you can, if you are rejected, bring a lawsuit, but you will have to bring it in Germany, because usually the German authorities reject it. And then you have to find a lawyer in Germany who brings a lawsuit either to the court in Ansbach, which is in Bavaria, or the court in Berlin. You can choose due to a weird procedural reason. But you need to have a German lawyer at that point. And there are a few organizations that also specialize on, and at least I know one between Greece and Germany, that specialize on these procedures, because it's really a way to enable people to come to Germany directly in a legal way, and in a procedure within the procedures. Then another criterion is visa, and you probably know that if a country gives you a Schengen visa, that country is responsible, and then only you get to the first entry criterion. And overlapping that, and this is what we work with a lot in Germany also when people come, is the question of anyway you cannot send back someone if there are systemic flaws in the asylum procedure. in that country, or if there is a threat of inhumane treatment, which is not always overlapping, but sometimes it's different. It's often different, bit different legal standards. And especially for the question of inhumane treatment, it is very important, and we touched upon this shortly a few weeks ago. It is very important that people, when they come through Italy and then to Germany, that they are really able to, also in the first interview in Germany, to really recount all the problems that they met in Italy. So this is also why it is for me very important, Jacopo, that what you talked about now, because I mean, we read a lot of reports about Italy and about the kind of the systemic difficulties that people hit, especially with finding work and the residence permit thing, because we have to argue in court here that it is very difficult for asylum seekers in Italy often to make a decent living, so that the courts would say that Germany is responsible for your case. And then this is a bit the procedure. I mean, what happens is that you lodge the application. They see that you have a Eurodac, so the fingerprints Eurodac hit, so fingerprint in another European country. Then they have to request that this country would take you back, and that country would answer or not answer. Then they can also, after a certain deadline, send you there. You get an inadmissibility rejection, and then you can still appeal to the court, and then you might get another rejection, or the court says maybe there's systemic flaws in Greece, for example. Right now, no one is sent back from Germany, actually. And what is also part of the Dublin regulation is this 6 months time frame that the authorities have to transfer you. So if they can transfer you legally to the other country, and they don't do that or they don't manage to do that for 6 months, then Germany becomes responsible for your asylum application. It's a bit difficult, because if they think that you absconded, then they can extend it to 18 months, which makes it quite difficult. Already 6 months is not easy to get over, but 18 months is definitely difficult. There are a few ways. I mean, there's you can get asylum in churches and so on to work with this, but it is also these 6 months is also a way for people to then, if they want to kind of see whether Germany might become responsible for their asylum claim. I had one thing that this leads to in Germany, and this is a problem for many people, and it's interesting what you said, Jacopo, because I can reciprocate that it's a problem for some people, and it's a blessing for others, that it can lead to endless procedures in Germany. You can have what can happen is that you get a rejection as inadmissible by the authorities, by the administration. Then you go and bring a lawsuit. Then maybe that lawsuit takes, again, I don't know, 1 to 2 years to be decided. Then they reject you again as they might say the rejection as inadmissible is unlawful, and they cannot give you a positive decision because it's only an admissibility thing. So the authorities get it back, and sometimes, I mean, I have seen cases where they reject it as inadmissible again, sometimes on other grounds, and you are in the loop again. So people get into this loop of procedures, and even if the administration says now it's admissible, then you would still have your material asylum interview. So on the merits, you might get a rejection by them again. You have to bring another lawsuit that again takes 2 to 3 years. So I have seen cases where I was involved in, and people were in procedures since 2013, 14, and still kind of in this loop of courts. and that, as you mentioned before, is good for some people. I mean, if someone comes from, for example, Senegal or Ghana, these are countries where they would have very little chances in the material procedure and in the procedure on the merits, and they can use this time in order to integrate and in order to take, I mean, by the latest in Germany, after 8 years, and they will bring this down to 6 years, you have chances to get a residence permit if you integrate well. So this is, I mean, for these people, it's good. But for example, then if it's Syrian refugees, it's pretty clear that they get a protection status, and it's incredibly frustrating if you're kept in these inadmissibility loops, and you cannot really arrive here. You still have a temporary and this, I don't know, but not very official looking document, which means, I mean, try and find housing in Berlin or Munich with something that doesn't look like a passport, or also, I mean, bank accounts, daily life. It's really inhibiting people to make use of their, if you're in these lawsuits all the time, yeah, people also spend money on lawyers and all that. So I mean, it's a blessing for some people, and it's a curse for others. And especially the authorities now started something new, which is that they found out, for example, if someone comes through Greece, that it's easier for them to reject them if they are from Western Africa, for example. It's easier to reject them on the merits. So they might just very quickly say, okay, Germany takes over responsibility for your case, and then give you a very quick rejection, which is another thing that we have to deal with now. And I don't know, we haven't found a good strategy to kind of get around this for these people. Because for these people, it used to be a blessing that you got a lot of time through the procedure. These are some of the strange things that happen through this admissibility procedure. And I just thought, while you were talking about one case that was that really shows how weird it can get, and I might tell about it a bit maybe. This was a family. There were, I think, so there were 6 people in this family. They were all in Italy before. So they came through a humanitarian visa from Lebanon to Italy. And then they were in the procedure there. And then because of the conditions they faced there, they moved on to Germany. And they were all rejected as inadmissible. There were 2 parents. They had 2 children that were minors. And then there was one daughter who was just 18. And they had a grandfather. So in total, this were 3 cases, 3 separate cases. The family with the minor children, the adult woman now, so the 18-year-old daughter, and the grandfather. And all of the 3 cases took completely different routes. So they were all rejected as inadmissible. Then at some point during the procedure, Germany accepted the grandfather as admissible and went through the procedure, and the grandfather actually got refugee protection. The 2 others, they didn't want to accept them. Then COVID happened, and these 3, also the court rejected them. The grandfather was quite ill, so he wouldn't be sent back to Italy. The court said you have to give him the material procedure in Germany. Then during COVID, the 6 months elapsed and they weren't deported. But what happened then is that for the 18-year-old daughter, they took her over into the material claims procedure, and they gave her subsidiary protection. And for the parents and so for the family, they then said, well, while this time elapsed, then we treat it as a new application after that. And at that point, Italy had already rejected your asylum claim, or taken back. I don't know. It was kind of I don't understand the Italian procedure enough to say what exactly happened. But they said, well, you were the procedure there was over. So we now treat your case as a secondary application. and then and then only new grounds for asylum would count, which was a problem for them because they had a story or a flight history of Syria, which they wanted to rely on. And then you would be in a second admissibility procedure that we had to go to court for. And this one is still not over. So it's completely, and for you have to imagine, for the people who are in this, it's completely crazy to have one family, they kind of all travel and belong together, and you get 3 completely different procedural routes through this crazy system. And I mean, they come to the office and they were, I don't know, flabbergasted by what, why do they get this decision now? Why can I not go to the material claims procedure now, and again inadmissible, and so on. Very, very weird what happens there. I just thought about this case now to illustrate. One thing that I thought about quickly that I wrote down here while we talked about the pushbacks thing is, and this is a thing that's also a problem in the inadmissibility procedure here, is that we get a lot of stories, especially from, for example, Croatia, but also Spain, of serious pushbacks where people were mistreated, traumatized by police officers. I'm thinking of one case where there was a minor child, and they were pushed back 6 times over the border of Croatia and beaten and mistreated heavily, so that the child was traumatized. And whenever the child saw, and apparently in the accommodation in Croatia, they had people in uniform, and whenever they saw something in uniform, the child would just go crazy. But when you are in the inadmissibility procedure in Germany, that doesn't count, because they would always say, well, you're not in danger. If you send you back now, you would not be in danger of a pushback anymore. You would not be in Spain in Melilla again. You would be on the main country. You would not be at the Croatian border again. You would be in the procedure in Croatia. So this is something that we can't really grasp right now legally, but which I find it's very relevant, and you have to then kind of try and get into a psychological a doctor's letter or so, because it is definitely a very relevant part of their flight history, but it's not recognized in the admissibility procedure. Finally, and then I will look at the clock for a second. Yeah, I might go on and to one thing I wanted to highlight in the material procedure, and they're basically, and we talked about this last time also quickly, that there is, I mean, and this is the same in all of our countries, so we won't have to go into it much, but there's, you know, that there's the international protection, which is the refugee status and subsidiary protection, which has to be the case in every European country, but there are certain cases that are not kind of, yeah, that don't fall in either protection, that are very relevant. And for that, and I would be very interested also to hear whether this is, I mean, I assume it's the special protection then in Italy that you talked about. We have the national deportation ban, which is a bit different from the special protection, because we have a quite strict division of in this procedure, in the status procedure, you only and exclusively look at the country where someone comes from. So you only look at, let's say, Somalia, and say, can this person make a living there? And as you know, in the refugee and status and subsidiary protection, you always have this problem that you need an actor who persecutes you, or who the threat comes from, basically. Of course, you can sometimes kind of say that the state is responsible positively for your condition there, but there are things, and especially I think this is a relevant topic for the 21st century. There are there are difficulties or that people flee from that are general in nature and that are not that don't really fall within the refugee or subsidiary protection, and these are things like economic difficulties and climate change, I think. And we kind of use this, so courts started to use more and more this national deportation ban to have a catch-all, and unfortunately not all catch-all title for these cases. And this is really in flux. I mean, during the last 10 years or so, this has, I think, changed also a lot in order to adapt to current situations. And basically, legally, it just says that there has to be a violation of your rights according to the ECHR, the European Convention of Human Rights, which is very, very open again. And then take Somalia as an example. You would look at, can someone make a living in Mogadishu? And the problem that we are dealing with right now is that the courts settled on this jurisprudence, but they kind of say there has to be an exceptional case, and we cannot take everyone from Somalia because it's a difficult situation there. And then it's not, your case is different from the general case of someone fleeing from Somalia, which is a bit weird in cases where you have a shortage of food stuffs and so on, where by nature everyone is hit by this. So what happens in practice is that you have the vulnerable groups who get protection, and the young and able men who fall out of everything. And it's always said, well, the construction business in Kabul is great. They can go back to Kabul, of course, and make a good living there. The construction business, and they always say the construction business for some reason in Mogadishu is also apparently great, and you can go back and make a living. Which leads to this weird situation where the technically least vulnerable groups becomes the most vulnerable group for the procedure, and you have to. It's the most difficult cases to get through somehow, and I think this will be a very, very important topic for the 21st century, because we will be confronted with more and more of these very broad threats to livelihoods and places, especially places that are hit by climate change. And climate change, I think, only to a very small degree will hit you or hit countries directly. Mostly it's food shortages. It's mostly the loss of people's livelihoods, and that also affects young and able men. So I think it's something that we will have to monitor and see where it goes, and something that we also, I think, in the discourse have to fight a lot, like in maybe in every court procedure, bring the argument that also for young and able men, it's difficult to make a living in Somalia. For Afghanistan, it changed shortly before the Taliban took over, that there were decisions that said only if you have very good family ties in Afghanistan, you can make a living there, and if you were one of the young and able men with good family ties, then they would still send you back. And now it changed to you cannot send anyone back, and most of the people get automatically this national deportation ban. So this is a situation, but also politically, out of political reasons, that where it's really recognized right now that you can't send anyone back now, in Germany at least. These were some of the things that I wanted to highlight. I think I don't know. Do you want to take a break, or do we want to take questions and then finish up? Or
I think we can take questions.
Yeah.
I mean, I think we skipped the break. So actually, there are a couple of questions for Lorraine about Greece. They are actually very specific. I cannot answer. So I think we have to ask Kyle to send these questions to Lorraine, or maybe to ask her in the next roundtable. She will be there too. So I don't know. I mean, if you have a I mean, if you know something about these questions, you of course you can answer, you can say something, but otherwise there's a question for Jacopo. Did you read it? Yep. So I don't know if you want to.
Okay, so the question is about the mail notification. So the question is, I understand this. What could be the best way to work about the notification? So how do you prevent those problems that I talked about? Well, the only way, and we have to be careful, is to explain this to our clients as soon as they lodge their application, and to intercept any client with an asylum application. And so it's like, the first thing that I ask is, let me see the paper with the address. So I don't care any of the other things. The first thing I want to, when someone comes, is let me see the paper from the address. Because I want to make sure, is this the address? Is this complete? Is this an address where you can receive the mail? And if it is not, we have a form already prepared, and we fill it in with the complete and exact address, and we send it to commission. Unfortunately, this is the only way, because the law puts a heavy responsibility on the asylum seeker, which in an ideal world would be okay. In a world where the asylum seeker is thoroughly and exactly informed of this, where they have a way not only to find a proper accommodation, but also to communicate with the police offices. But in this, and the Italian, I mean, I don't know about other countries, but in this world, in this country, where it is impossible to communicate with the police office unless you are a lawyer, and they don't even answer to you, to the lawyers, but at least you can have evidence that you communicated the exact address. But not only that, no one explains this, even though they're supposed to receive an explanation, but the explanation about the address is just on paper. Like all the other information is always just on paper. But this is I think it was very clever by the government to put this apparently very tiny and marginal detail, like how do we send the information? But that was very clever, and it is in the same way as it is with a criminal case, where if you don't let the court know your whereabouts, then they will not look for you. Now, there is a difference though. In the criminal case, you have a lawyer. Even if you don't appoint a lawyer, the court will appoint a lawyer for you. And the lawyer has a duty. Now it's become even more a heavy duty to inform the client or to take action, even if not instructed by the client. So it's not that the lawyer can say, okay, there is a hearing. I don't know if the client has received the information, I'm not going. No, the lawyer has to go. And the lawyer can do most of the job by him or herself. This is not the case with the international protection. You cannot send a lawyer to represent you in the interview, and you cannot let a lawyer lodge a case in the court against a negative decision. So the responsibility placed on the shoulders of the asylum seekers is very heavy, and information would be the key. We try to give this information, but I see we do not succeed, because even though we are very clear and insist on this, most of our clients don't realize, and then they come back with incomplete addresses, or they don't realize and they say, oh yeah, I changed address, I moved to a different place, but I will tell the commission, I will tell the police office later on. No, you have to do it right away. This is something that only if you are in contact with the asylum seekers, or only if the asylum seeker is in contact with a lawyer, with an organization, can do. Otherwise, they are they have to rely on good luck, like the letter was not sent for 4 years. This can be, but if they are not lucky and they don't have this kind of external help, I don't know how they can do, because this is clearly a law designed to prevent asylum seekers from accessing or exerting their right to asylum in a clever but evil way, I should say, because this is like a way not to examine and evaluate the claim.
Okay, I don't know if there are other questions, because it seems there are no more questions, which is unusual because there are always a lot of questions. Maybe you were so clear and okay, if there are no other questions, I think we can finish here. Okay, thank you for being with us. Thank you, Jacopo. Thank you, Andreas. Thank you very much for your contributions, and thank you everybody for being with us. And we will see each other on Thursday with the last round.
Thank you very much for the invitation.
Thank you. Bye.